Welcome to Susquehanna Legal Services Landlord-Tenant Video Workshop. My name is Pete Mackey, and I'm the Managing Attorney of the Sunbury office of SLS. This is the second in a series of 3 videos which we have produced on landlord-tenant law. In this video, we will examine basic topics which arise during the landlord-tenant relationship. Among those topics are the following: oral and written leases, before you rent, landlord and tenant duties and responsibilities, proper eviction procedures, illegal eviction methods, security deposits, mobile home parks, and at the end of the video we will return with a landlord and tenant quiz to see how much you have learned. If you want to watch all the topics in the video, please do so. The video runs about 40 minutes. If you only want to watch some of the topics, you may fast forward the video to the number which corresponds to the number on the screen now. For instance, if you want to watch security deposits, you would fast forward until you see a number 6 in the lower left-hand corner of the tape. At various points during the video, we will return for a panel discussion featuring Cynthia Whitman-Daly, who's an attorney with Regional Housing Legal Services in Harrisburg, J.P. McGowan, who is an attorney with the Bureau of Consumer Protection in Scranton, and Gary Wamser, who is the managing attorney of our Bloomsburg office. We hope that you find this video to be informative and enjoyable. Hi, Mrs. Harrison. Pete Mackey. Do you want to have a seat?
Thank you.
I understand you have a housing problem, a question about a lease.
I've been looking for a bigger apartment for several weeks, and I saw one that I liked yesterday. The landlord wants me to sign a written lease. He's given me a copy.
Okay, thank you. This is a form printed lease, probably printed for the benefit of landlords by a real estate company or something, or a landlord's attorney. And it has several provisions in here which are helpful to the landlord. For instance, I see an acceleration clause here, which means that if you move out during the term of the lease, you have to pay the entire amount of the rent for the balance of the lease. And I also see a provision in here where you give up your right to a court hearing if the landlord attempts to evict you.
But he said I have to sign it.
Well, it's true. Landlords can make tenants sign written leases. The housing supply is so small for affordable housing that landlords do have certain advantages. And one of them is that they can demand that the person sign a written lease. And if that's what they want, the tenants have to sign the leases.
But I don't have a lease at my current place.
Yes, you do. You may not have a written lease, but you have an oral lease. An oral or verbal lease is just as enforceable as a written lease. In fact, they can be enforceable for up to 3 years. Now, in most cases, if the parties haven't agreed to a specific term, an oral lease is considered a month-to-month lease, but it's just as valid as a written lease.
What good is a written lease for me?
There are pluses and minuses, and it may not do a lot of good for you. There are a couple of pluses. One of them is that if you really like the place and you sign the written lease, then you do have assurance that you'll be able to stay there for the balance of the term. Usually it's a year, and I think in that case the lease you have there is a year's lease. Another advantage is that you know that the rent will stay the same for at least a year. Disadvantages, though, are you may not be sure that you want to stay in that place for a year, and yet if you sign the written lease, you're locked in for a year, and you have to pay the rent for a year. Another disadvantage may be that you've given up a lot of your rights by signing that written lease, and there are provisions in there which are potentially harmful to you.
Well, what should I do?
Well, the landlord can make you sign the lease. However, there's no harm in discussing with the landlord parts of the lease which are really harmful to you and parts that you don't want to be bound by, and you could ask the landlord to scratch out those parts of the lease. And perhaps the landlord will, The bottom line, though, is if he wants you to sign the lease as it's written, you must do so. Now, I will say one other thing, and that is that Pennsylvania passed a law called the Plain Contract Language Act a few years ago, and that does apply to leases. And it does require that leases be in plain language, be easily understandable to lay people. And if there are breaches of that statute, if the lease doesn't fulfill the requirements of the law in terms of being easy to read, then those portions of the lease can be unenforceable. However, you're running a risk in relying on that law to save you if problems develop at the end.
Okay, well, thank you for helping me.
Good luck to you.
Thank you.
Before you rent, make sure you have thoroughly inspected the apartment. You should know the answers to these questions. How much rent will I pay? Which utilities must I pay? How much will the utilities cost? What is the condition of the plumbing, wiring, heating system, and any appliances owned by the landlord? What is the condition of the apartment and building itself? Windows, walls, roofs, or locks? Are there any repairs which need to be made? Who's going to pay for the repairs? Does the apartment have enough rooms? If you decide to rent the apartment, try to get the landlord to write his promises down. Always get a receipt for your rent or security deposit. Before you move in, make a checklist of problems such as cracked windows or holes in the wall. Better yet, take pictures or videos of the condition of the apartment. If possible, have a friend or relative tour the apartment with you. This protects both you and the landlord. You are responsible for damages you cause. You are not responsible for damages which were there before you moved in.
Well, panel, we've now seen the first two vignettes in the video. The first one dealt with the differences between oral and written leases, and the second one dealt with practical information which tenants and landlords should be aware of before they enter into a lease. I'd like to focus in this discussion on the duties and responsibilities which apply to both landlords and tenants during the landlord-tenant relationship. First of all, Gary, one of the points that was made in the first vignette is that a lease is, if it's a written lease, it's presented to the tenant, and there's very little bargaining position for the tenant. Do you have a thought about that?
Well, you can do some bargaining. You can always try to negotiate, and I think it's good to get on a good working basis with your landlord when you first start out. In fact, you may learn when you try to negotiate some of these things whether this landlord is one you can work with. And I think with both vignettes, that seemed like a really good idea.
The lease itself that I was looking at in the vignette, as I said, was a foreign printed lease, and it had a lot of what we call legalese in it, terms which are not well known. JP, the plain language law that I mentioned in the vignette, what effect does that have on a lease like that?
Well, the plain language law does apply to consumer residential leases, so they should be written in language that your average layperson can understand readily.
And in truth, I think a lot of landlords don't understand the language either. Cindy, when we looked at the vignettes, we talked about practical things that could be done. There are also rules and laws that landlords have to be aware of when it comes to renting apartments and advertising for apartments. Isn't that true?
There's the Fair Housing Act, the federal act, as well as state law, local laws in many jurisdictions, which will protect people not only on the basis of race, religion, national origin, gender, marital status, presence of children in the home, disabilities. So yes, it's important to be aware of those.
And Gary, how important do you think it is for the tenant to thoroughly inspect the apartment before he or she either agrees to an oral lease or a written lease.
It becomes very important to make sure there are no real serious problems after you've moved in, and that when you are ready to leave, that there won't be damages that are claimed that are yours. So.
JP, a landlord has certain obligations to the tenant, and a tenant has certain obligations to the landlord. What would you consider the most important obligations that the tenant has to the landlord?
Well, obviously, the landlord would consider it to be paying the rent, needless to say, and that is, of course, a big obligation to be done on time. The tenant has to keep the premises in a reasonable state of repair. In other words, cannot do damage to the premises, or else they may find that their security deposit is used to pay for such repairs. Or worse yet, they may find themselves being sued by their landlord after they move.
Okay. Cindy, the landlord, on the other hand, has responsibilities too, and certain rights, as JP mentioned. What are some, in your view, some of the most important responsibilities that, or duties that the landlord owes to the tenant?
Well, clearly to maintain the property. With rare exceptions, and you always have to look at a written lease to see what's in the lease, it's the landlord's responsibility to keep the property habitable, livable, and provide heat, which doesn't necessarily mean paying for the heat, but making sure that heat and utilities are available for the property.
Is the tenant's duty to pay rent ever suspended?
If the property is not maintained and it becomes unlivable, then the duty to pay rent could be suspended, or the amount of rent due could be reduced.
Gary, there's an interesting provision in the law which many people don't know about that applies to utilities, which the landlord is responsible to pay. If the landlord doesn't pay those utilities, does the tenant have any remedy?
Yes, very important statute that says if the tenant is going to suffer because the landlord is not paying the utilities and the utilities are going to be shut off, the tenant has a right to be notified first, a right to pay for the utilities and deduct it from the amount of rent they owe.
And if the tenant does that, can the landlord evict the tenant for non-payment of rent?
It's considered a retaliatory eviction, and the statute says it's not permissible.
There's even a more unknown statute, and that is one that if the landlord doesn't pay his real estate taxes, the tenant can pay the taxes and avoid an eviction based on non-payment of rent. Any other thoughts people have on the responsibilities and rights that respective parties have in these landlord-tenant relationships?
Just one.
Okay.
I noticed there's a change in the law that allows now that if there's a judgment for damages to the property, tenants' wages can be attached to pay for those damages after they left. This makes it really important to maintain the property while you're in and make sure that there's a clean understanding of what damages were there when you moved in.
Along those lines, I think the idea of bringing a camera in, or in this day and age, video cameras are very common, and taping it when you first move in, and with the date right on the screen, so that there's little argument that that broken window was there when you moved in, and that you didn't break it.
Two thoughts when you're looking at an apartment. One is to make sure that you're only paying utilities for your own apartment, and that it's separately metered if it's a multifamily building. And the other is that landlords are required to notify tenants if they have any knowledge of lead-based paint in the apartment.
Thank you, panel. Keep in mind, viewers, that there are written materials available in addition to this video, and information will be provided at the end of the video where you can obtain such additional materials about landlord-tenant topics. Hi, Catherine Steele.
Hello, how are you?
Hi, have a seat, please.
Thank you.
I understand you have a problem with your landlord.
I've been served an eviction notice for being 3 months behind in my rent.
Okay,
My
thank
cousin
you.
says it's not legal, though, because It's not notarized. She used to work in a courthouse.
Oh, okay. Well, your cousin's wrong. That's one of the what we call the great myths about landlord-tenant law, that something has to be notarized in order for it to be a valid eviction notice, and that's not correct. Actually, an eviction notice is valid if it's presented to you in person or put on your door. If it's in writing from the landlord, that makes it valid. It doesn't have to be served on you by a constable or sheriff. It doesn't have to be notarized. So this is a valid eviction notice.
It only gives me 10 days, though. Is that legal?
Unfortunately, it is now. It used to be until a couple of years ago that if you're behind in your rent, you could count on a 30-day eviction notice from September through March and 15 days from April through August. But the legislature changed the law, and now if you're behind in your rent, you're only entitled to 10 days. You're also only entitled to 10 days if you've been convicted of drug-related criminal activity. Now, if the term of your lease is up, or if you're being evicted for some other reason, you're entitled to a 15-day notice if the lease is for a year or less. If it's for more than a year, you're entitled to 30 days. It used to be 3 months. Now it's only 30 days.
Wow, that's confusing. What if I can't find a place to move to in 10 days? It's really hard, you know.
Yes, it is. The housing market's tight. There aren't a lot of places. Unfortunately, the way the law is, you're entitled to a 10-day notice, and at that point, if you haven't been able to find a place, then the landlord has to take certain other steps. You don't have to move out at the end of 10 days, but that does start the process going.
Well, if he wants me out that badly, he's got to find me another place, doesn't he?
That's landlord-tenant myth number 2. The landlord has no obligation to find you another place and no obligation to give you a good reference.
Well, at least I don't have to pay the rent, according to my cousin.
You should ask her what year she graduated from law school and where she went to school, because that's not true. You do have to pay the rent. You're under a continuing obligation to pay rent as long as you live there.
If my landlord sues me, do I have to leave then?
No, the second step of the process is he files a complaint against you. And it has to be served on you by a constable or a deputy sheriff, and it also has to be mailed to you. And the complaint filed in the district justice office will give you the reasons for the eviction and also tell you the time, place, and location of the hearing.
Do I need a lawyer?
Well, a lawyer probably would be helpful to you, but the district justice court is set up so that people can present their cases without a lawyer.
I don't think I should have to pay all the back rent. The furnace only worked occasionally. We were cold all winter and we had to buy a space heater. The landlord never fixed the furnace.
In that case, then you may have the right to file a cross-complaint against the landlord. And you would do that by going to the district justice office and explaining the situation and suing the landlord for damages. Now, in the case of lack of heat or lack of sufficient heat, you would have to estimate what you feel the apartment was worth without the heat. So, for instance, how much was your rent?
$300.
Okay. If your rent's $300, then if you had no heat at all during the winter, perhaps the apartment isn't worth anything. If you had some heat but it wasn't adequate, perhaps the apartment was worth $200. This is something where you have to make a good faith estimate. You could sue the landlord for damages, and you would file a cross complaint, and it would be served on the landlord, and probably the district justice would schedule a hearing for the same time and date as the hearing on his eviction against you.
But I really want to stay.
Well, the bottom line is that if you breach the lease or if you owe rent, the landlord probably can get you evicted. He probably is going to win the hearing. Now, if the conditions of the place were really bad and you can prove to the district justice's satisfaction that you shouldn't owe any rent because the conditions were so bad, then perhaps you'll win. But generally speaking, when you're behind in the rent, it's going to be really hard to win such a hearing. The landlord probably is going to win.
I have to leave that day?
No, you don't. The hearing is really step 3 of the process. Step 1 is the eviction notice. Step 2 is the notice of the complaint, notice of the hearing. Step 3 is the hearing. And you do have a time after the hearing to decide whether or not you want to appeal. And during that appeal period, he can't do anything to you. He can get an order for possession 10 days after the hearing if you have not appealed. And then 10 days after that, he can forcibly evict you. So 10 days after the hearing, he gets the order for possession. It has to be served on you, and that paper tells you you have 10 more days to move. So actually 21 days after the hearing is the soonest that you can be forcibly evicted. And that's, of course, if you don't appeal.
Well, what if I want to appeal?
It isn't hard to appeal the money judgment portion of the case, but it is hard to appeal the eviction portion of the case.
Why is it so hard?
The money judgment portion you can do within 30 days by filing a form in the prothonotari's office. That's not hard. The harder part is filing the eviction appeal. You've got to do that within 10 days. And also you have to post a bond worth either 3 months' rent or the amount of rent found to be due by the district justice. And also you have to continue paying your rent into court as it comes due. And of course a lot of tenants can't afford to do that.
You mean if I don't appeal, they can kick me out on the streets?
Yes, you can eventually. You've got the 10-day appeal period, and if you're not out then and you don't appeal, then the landlord can get what I call the order for possession. And 10 days after it's served on you, you can be forcibly put out in the street. Also, another change in the law, the landlord can get your wages garnished or attached if you have done damage to the apartment. Now, it has to be serious damage. This doesn't apply to back rent. This applies to property damage that you did. If the district justice finds that you did that, then your wages could be garnished.
What if I come up with the money to pay the judgment? Could I stay then?
Well, if the judgment is strictly for non-payment of rent and there are no damages involved, then you can stay if you can pay the entire amount due. That's called the pay and stay rule. It's Rule 518 of the district justice rules. And it does wipe out the eviction judgment, and it wipes out the case entirely, so you would not have to move if you can pay the entire amount. But you've got to pay it all before the constable comes with the paper to forcibly evict you. Now, it used to be that there were a longer appeal period, a longer time scheduling the hearing, and a longer period for the eviction notice. But the legislature in 1995 changed things and made it harder. You still do have the right, though, to an eviction notice, notice of a hearing, the hearing itself, and an appeal period, even though these times are reduced from the day that you get the eviction notice until the day that you are perhaps forcibly evicted from the apartment by a constable because a judgment's been entered against you. That time period can be as little as 38 days. Let me turn to Gary first and ask if he has any comments about the much more restrictive time limits that are in place now in the state.
Yeah, many people still have this sense that they have a much longer time period. I've had many clients who think that you have to have 90 days before you can actually be told to leave. And I think they confuse the amount of time it took from the notice to the sheriff putting you out the door. That's been shortened now to about 45 days.
Now, in the vignette, we mentioned that the constable can actually come in and forcibly evict the tenant at the end of the proper notice, hearing, appeal period. If that isn't appealed, the order for possession. JP, I think a lot of people don't realize that that can actually happen. What can a constable or sheriff do with a valid order for possession at the proper time?
They can literally remove you forcibly if you refuse to go.
And what do they do with your property?
Well, that, I believe, can be removed from the premises and just left there at the curb or taken by them.
A landlord may run a risk if he does that, but certainly the property can be either kept in the premises and locked, or it can be taken to a storage area. and I'm sure many landlords do leave it on the curb, but I think that if they do that, they are running a risk of a damage suit from the tenant. Cindy, in the vignette we mentioned briefly that in Pennsylvania now your wages can be garnished. This is very unusual. There are only a couple of situations. There's child support, there's back taxes, and now there's garnishment for damages done to the premises. Can you talk about that a little bit?
That's true. That is a new law. There are some provisions, some protections for the tenant. First of all, the landlord must first look to the security deposit and use that to pay for any damages. If the damages exceed the amount of the security deposit, then wages can be garnished up to 10% of the person's wages, as long as that won't put them below the poverty level.
Now, would this apply to ordinary wear and tear or just to excessive damage?
No, ordinary wear and tear is always expected in a rental situation. It would just be excessive damage.
Cindy, we also mentioned in the vignette that the notice to quit is governed either by the state law or the lease. The lease can provide for the same amount of time as the statute or the law. Can the lease provide a more generous time period or a less generous time period than the law permits?
Yes, it can. The law states that if you have a written lease, that the amount of time provided for notice to quit can be reduced or even waived altogether, so that it's not uncommon to find a written lease that provides for 5 days notice to quit or even no notice.
If a tenant is examining the lease before signing it and sees that provision and is able to understand that they're giving up their notice to quit, it could be that the landlord doesn't realize that because it's a form lease, and that could be something that the tenant could negotiate with the landlord back into the lease.
That's certainly possible. That there is always a possibility of negotiation. As you pointed out, the landlord may be in a better position because the landlord has the property, but there are things to negotiate, such as the amount of time.
Gary, when JP was talking about the legal eviction at the end, after the hearing, after the appeal period, the constable can come in and actually forcibly move the person out and secure the property. If the tenant comes to that dire situation, what practical things, what's left for the tenant to do?
Well, in my county at least, the sheriff will escort them out the door and lock it behind them, and then they'll have to work with the landlord to get back their property. If a tenant is in that situation, they should, of course, remove all important things they can't afford to lose. Papers, clothing, things for the children. Because things that are left in, you've got to go back and negotiate with that landlord, and it's very difficult to do.
I understand that your landlord put a padlock on your place, and when you found it when you got home today.
He gave me eviction notice, and he says he wants me out by next Saturday, and I haven't been able to find a place to stay. It's hard to find a good place this time of year.
Have you talked to him since you found the padlock?
Yes. He said if I don't have the money by next Saturday, he was going to dump all of my stuff out.
And he won't let you back in?
And he won't let me back in.
Okay. Do you have
any of my things?
Do you have anywhere else to go?
Well, I could go to my mother's, but it's me and the 3 children, and there's not enough room.
Did the landlord say he'd let you get your property?
No. In fact, he put a padlock on the door. I can't get back in to get any of my stuff, and he says if I don't pay him by next Saturday, he's going to dump all my stuff out on the street.
What he's done is called self-help eviction, and in Pennsylvania that's considered illegal. He has given you eviction notice, which is the first step of the legal way to do it. The next step would have been for him to go to the district justice court and file a complaint against you, and then there'd be a hearing and a time for appeal. But he short-circuited all that and took the law into his own hands. It is considered illegal both to put the padlock on and to threaten to throw your things out. Would you like to get back into that place?
It would be nice to get back in, but you know he turned the heat off last week just to drive me and my children out of there.
That's another common example of self-help evictions. Fooling around with utilities, padlock, I've had landlords who have removed the doors. I've had landlords who have actually removed the personal property, and I've had landlords who have thrown things out of the window onto the street. So that's all illegal. However, since he did give you an eviction notice and you are behind in the rent, if he goes about it the right way, he probably will be able to evict you eventually. It just won't be the way he's done it. Okay, what I'm going to do then is I'm going to call your landlord and see if I can get him to take the lock off. We have to try this before we go to court. So let me give him a call. What's his phone number?
It's 671-0798.
Okay, let me give him a call. Yes, this is Peter Mackey from Susquehanna Legal Services. I'm sitting here in my office representing one of your tenants named Gina Smith, and she tells me that you put a padlock on her door. Yeah, I know. I know that she's behind in the rent. I understand that. Yep, I know. But it's illegal to put a padlock on the door. You have to go to the district justice. I know that you gave her an eviction notice, and that is the first step in the legal process. And you then would have to go to the district justice and file a complaint, and there'd be a hearing, and then she would have a right to appeal if she wanted. But that's the proper way to do it. Yeah, I know. I understand that you have obligations. There's no question she owes you the rent. There's no question whatsoever. And I understand that you also turned the heat off. Right. When the heat didn't work, then you went to the padlock. Well, both of those are illegal. They're self-help eviction, and that's not favored in the state. In Pennsylvania, you're supposed to go about it through the law. Keep your disputes within the legal system. If you don't take the padlock off and restore the heat, we're going to have to go to court and ask the court for an injunction against you to order you to do those things. Well, we would probably be ready to go today, but I'm giving you an opportunity to correct these problems before we do that. I would prefer not to go to court, but we would have to do that in order to get her back in her apartment. Okay. Yeah, I know. I understand. I understand that she owes the rent. Yes. Yes, I will help her. We'll try to find and try to make sure that she looks hard for another place. And maybe she'll be able to come up with a rent for you. I don't know. Or part of it anyway. She also said that you threatened to throw her things out. You haven't done any of that, have you? Okay. That was just a... You didn't intend to do that. Well, that's good. Okay. All right. You're going to take the padlock off and restore the heat. Okay. That's great. Thank you. Let me give you my phone number in case you have any questions. It's 286-5687. Thank you. Goodbye. Okay. He said he's going to take the padlock off. He is really upset because he has a mortgage to meet. And if he doesn't get his rent, of course, he doesn't get to pay the mortgage. So I can understand why he's upset. He certainly has every right to expect his rent, and it doesn't really matter what your excuses are. You may have a good excuse. In your case, I think you got laid off and you don't have the income. And that makes it really tough, and especially tough because it's hard to find another place these days.
I've got a new job, and I'm expecting my tax return, and that should catch me up.
That's good. What you might do when you get back in is talk to him, and if you think that there's a chance that you're going to get a good amount of money within a short period of time, and you have some guarantee that you're going to get it, like the tax return. Have you already filed your return?
Mm-hmm.
Okay. Do you want to stay there? Do you like the place?
Yes, I love the place.
And how about him, now that he's done this to you? Are you willing to stay there under these circumstances?
Well, now that I know my rights, I'm not afraid.
In that scene, we watched a tenant coming to the lawyer with a typical complaint, and that is that the landlord has padlocked the apartment and hasn't gone through the legal process. We call that self-help eviction. JP, could you provide us with a practical working definition of self-help eviction?
Well, basically, it's when the landlord does anything on his or her own that's not allowed in the statutes. I mean, basically, there are provisions as to how you're you should proceed through the legal system to accomplish getting this person removed. And if you just take it upon yourself to change the locks, etc., whatever you may do, you, the landlord, are basically breaking the law, and it's something that the tenant could rightfully complain about.
And in Pennsylvania, at this time, would you say that the courts favor or do not favor self-help eviction?
I would say that the courts generally do not favor. I don't think they really ever have favored self-help evictions, and with the changes in the landlord-tenant law, which are more favorable to the landlords in terms of speeding up the process, I would think that the courts are going to look less favorably on any self-help actions.
Okay. Gary, do you think it's usually that easy to get a landlord to take the padlock off, as easy as we saw in this vignette?
Well, often you can accomplish things. No one really wants to get involved with lawyers in the courts, and it's easier if they comply and follow the law than if they don't. And so usually you can talk a landlord into complying. If not the first time, certainly the second time.
And if they don't comply, Cindy, the legal remedy for the tenant is to file an injunction or to ask the court for an injunction. What would the court look at in examining that request, and what would an injunction do?
Well, the injunction would force the landlord to let the tenant back in. What the court would look at would be a balance of, or look to weigh the harm to the tenant against the harm to the landlord, the harm to the tenant of being locked out, the harm to the landlord of letting the tenant back in. And since there really is a legal procedure for the landlord to follow, as JP said, there isn't any harm to the landlord in this instance, or very little harm. And so the courts would generally favor an injunction to allow the tenant back in.
Gary, has that been your experience?
Yes, by now I think the courts are routinely granting injunctions, and the attorneys who practice, at least with my area, are advising landlords that the courts will do that. And so if they seek independent advice, that's usually what they're getting.
What are some of the forms of self-help eviction that you've seen over the years?
Well, there's creative ones. Some people do a renovation project that includes removing the windows and doors. One of the most creative I saw is where they had the building condemned, so the code enforcement people could then evict all the tenants as being in a condemned building, then went in and repaired it. You know.
Utility shutoffs, padlocks, doors being removed, furniture actually put out in the street or taken and stored somewhere.
Right.
Furniture thrown out of the second-story window.
Yeah, but a landlord who does that is really at risk because they're responsible for the value of that property, and the cases are real clear on that. If they get rid of the property, they owe the tenant.
It says after I move out, I have to give the landlord written notice of my new address.
You also have to return the keys, do no damage, clean it, and leave owing no rent.
Well, I did all that. Let's see. The landlord has 30 days from when he got my letter to send me the deposit or a list of damages, cost of repairs, and any money left over.
What if he doesn't?
I can sue him for twice the amount of the deposit, and he can't keep any of it.
How do you sue him?
In District Justice Court. This book tells you how to do it.
What else does it say?
It also tells you how much the landlord can require as a security deposit and whether or not you can get interest on your deposit.
The security deposit law is a fairly complicated law which applies to the manner in which a landlord can hold a deposit from the tenant, which is to cover damages or back rent, and then how the landlord must return that deposit at the end of the tenancy. Cindy, the vignette we just saw is really just scrapes the surface of the security deposit law. What are some of the more interesting features of it?
Well, the first thing you need to know is even before you move in, how much the landlord can collect, which is the equivalent of 2 months' rent. During the first year of the lease, the landlord can hold 2 months' rent. After that, if you stay more than a year, the landlord has to return 1 month's rent and can only hold 1 month. And that if the rent is increased, the security deposit can be increased unless you've been there more than 5 years, I believe it is.
Is there a point at which the tenant is entitled to interest?
After 2 years.
I think that's right, yes. And many tenants think that they can not pay the last month's rent and use their security deposit. Is that true?
The tenant is obligated to pay rent. Now, some landlords actually collect what they call last month's rent up front, and in that case, tenant's already paid it. But if they haven't, the security deposit is there for damages or unpaid rent at the landlord's option, not at the tenant's option.
So if the tenant moves out and does damages, and the landlord serves notice of the damages and deducts the damages from the deposit, and the tenant hasn't paid the last month's rent, what can the landlord do?
The landlord could hold the balance of the security deposit toward the last month's rent, and if the amount of the rent due and the amount of the damages due exceeds the security deposit, the landlord can sue for the difference.
JP, in your opinion, can a landlord have a provision in the lease, in a written lease, which says that the security deposit will not be returned?
No, that is something that cannot be waived. That would be the opinion of our office.
It's right in the statute.
And it's pretty much right built into the law, that is a right that the person has. In fact, if you move, your only obligation is to give your forwarding address to the landlord, and everything else falls upon the landlord in terms of obligation to notify you how the security is being used, and if not, to give it to you within a certain time period.
If the lease contains such a provision, would that be a violation of the
That could be
fair trade?
construed as a deceptive practice, yes.
Okay. Gary, do you have any thoughts you want to add on the security deposit law and how difficult it may be to extract that deposit once the tenant has moved out, even if they've left the place in immaculate condition?
It can be difficult, and you can often get a landlord who will send you a letter saying the whole amount went for cleaning or something like that. It can be very frustrating at times.
And if the landlord makes repairs which would be considered ordinary wear and tear on the property, can that be deducted from the security deposit?
Again, not legally, but you may find yourself in magistrate court trying to sort those out.
So the tenant's remedy, if they don't get the deposit back or don't get as much back as they think they should, is what?
Magistrate court.
Okay.
We also see complaints like that from time to time, people trying to get security deposits back, landlord coming back and saying, well, I used it for painting, for example. Well, if someone's lived in a house for 6 or 8 years, the rooms may need to be painted. That could be considered normal wear and tear. So there's a fine line sometimes, but many times the landlords try to cross over that fine line and keep security deposits when they shouldn't.
Cindy, what laws apply to mobile home owners?
Pennsylvania has a statute called the Mobile Home Park Rights Act, which applies to people who own a mobile home and rent space in a mobile home park or manufactured housing community. And a mobile home park is defined as a land owned by another person which has room for 3 or more mobile homes.
So the law does not apply if there are less than 3 mobile homes in the space, in the area, and it does not apply even if you live in a mobile home park if you don't own your mobile home.
That's right. If you don't own your mobile home, you're simply a tenant, and landlord-tenant law applies.
Does the landlord-tenant law apply to the residents of a mobile home park who own their mobile homes?
Yes.
So both laws apply.
That's right, because people who own their mobile homes also rent the space in the park.
JP, what are some of the special rights or rules that apply to mobile home owners in these circumstances?
Special rights of the persons who reside there really key on how you can be evicted and for what reasons. And there's basically 4 reasons that you can be asked to remove yourself. One is the obvious non-payment of rent. Another is if there is a termination of the park, if the park owner decides to close, or if that portion of land where your unit is situated is being changed to some other use, or finally, if you have violated whatever park rules and regulations may exist.
Okay. And Gary, how are these rights enforced? What are there special time periods which apply? Does the landlord have to go through additional steps before they can evict the mobile home owner?
Yeah, there is a special provision for eviction if you own your own mobile home. There, the notice has to be certified or registered mail. There, you have to be given at least 1 warning notice. So you can only be evicted for breaking the rules if you do it for a second violation of the rules within 6 months of the first notice. Same thing with non-payment of rent. You have to be given a certain amount of time to cure the rent, and they can only move to immediate eviction if there's a second non-payment within 6 months of that notice.
And Cindy, are there special time frames added or available to the mobile home owners? And are those time frames different from the typical tenant?
Well, as we said, there are 2 laws that apply to mobile home owners. One, the Park Rights Act, and Gary just described the type of notice that's required under that. There is also provision in the Landlord-Tenant Act that applies to mobile home park residents and owners of their homes who are residents in parks. And there they do get slightly longer notice than the typical tenant.
Cindy, we've mentioned that there are special time limits which apply to mobile home owners. Can you discuss what some of those are?
Yes, and it does get a little confusing because, as we said, there are 2 laws that apply to owners of mobile homes in parks. As Gary described, if someone hasn't paid their rent, they get 20 days notice to pay. But then if they haven't paid, the landlord-tenant law sets in, and there they have slightly longer notice requirements than a typical tenant would, so that somebody who has a lease for less than a year would get 15 days notice if it's during the warm months, 30 days notice if it's during the winter months.
And the winter months are September through March.
September through March. And if it's for breach of lease, again, as Gary said, under the Park Rights Act, there have to be 2 breaches within a 6-month period. And if the tenant hasn't corrected the violation, then notice is given under the Landlord-Tenant Act, and that's 30 days if you have a lease of less than a year, and 3 months if you have a lease that's a year or more.
It is confusing. And fortunately, there are written materials which are available. We have charts in our landlord-tenant handbook, which I think are very helpful because this is difficult information.
Yeah, I think Pete, if you own your own mobile home, getting evicted can be really devastating, and people should consult a lawyer.
Yeah, this is probably, and I think one of the most interesting things is that if person living on lot 1 owns their home in a mobile home park, they're entitled to these protections. If person living in lot 2 is renting from the landlord, they are not entitled to these special protections. JP, does the Bureau of Consumer Protection have a role to play in the landlord-tenant relationship as it exists in mobile home parks?
Oh, certainly, because the Mobile Home Park Rights Act not only provides for a right of private enforcement, which means you can go hire a lawyer and take action yourself, but it also provides for enforcement by the Attorney General's office. So a violation of any of the terms of this law by the owner of the park is a violation of the consumer protection law as well, and could subject the park owner to civil penalties of up to $1,000 per violation.
At the end of the video, we'll have information on the screen which people can refer to if they want to get in contact with the Bureau of Consumer Protection or other materials that we've mentioned in the video. Why, Gary, do you think the legislature has chosen to give additional rights to mobile home owners?
Because they're not just renters. They own their own home. It's the space they're renting. And the special protection is because it's very costly to move a mobile home, and it's very difficult to find a good alternative space within a short amount of time.
And some of the homes that are in these parks have been there for many years and are older.
And that raises a problem right there, because they become unwelcome in many other parks. So the owner faces a difficulty if they've lived in a certain park for 10 years and now they're trying to move this older home. They may not be wanted in any of the better parks.
Right.
Now we'd like to have some fun and see how much you've learned. True or false? In Pennsylvania, an oral lease for more than 1 month is not valid. False. An oral lease can be enforceable for a term of up to 3 years. Number 2. In Pennsylvania, a landlord may raise the rent once during a written lease term. False. A written lease generally locks in both parties to a certain rent. Number 3. In Pennsylvania, your landlord may charge you a 2-month security deposit when you move in. True. However, after the first year of the lease, he may only keep a 1-month deposit. Number 4. In Pennsylvania, an eviction notice must be witnessed or notarized. False. Number 5. In Pennsylvania, every tenant is entitled to a written eviction notice. False. Unfortunately, a tenant's right to receive an eviction notice can be given up in a written lease. Number 6. In Pennsylvania, if the landlord does not fix the furnace, the tenant can repair it and deduct the cost from his rent. True. However, the tenant must notify the landlord and give him a reasonable amount of time to fix it. Number 7. In Pennsylvania, a tenant cannot be evicted between November 1st and March 31st. False. A tenant can be evicted at any time. Number 8. In Pennsylvania, a landlord does not need a reason to evict a tenant at the end of a term. True. This is generally true. Public housing tenants or mobile home tenants may have more rights. Number 9. In Pennsylvania, self-help evictions are considered legal if the tenant is 3 months behind in rent. False. Self-help evictions are illegal. Number 10. In Pennsylvania, persons renting mobile homes are entitled to additional rights. False. Persons must own their mobile home and live in a mobile home park to get those rights.